Chapter 12 Limited Liability Partnership Act 2008. Chapter Overview LLP. In this chapter, we are going to learn Introduction, Incorporation, Partnerships and their relation, Financial disclosures, Winding up and dissolution, differences with other forms of organization in respect of LLP. Introduction. The Ministry of Law and Justice on 9th January 2009 notified the Limited Liability Partnership Act 2008. The Parliament passed the Limited Liability Partnership Bill on 12th December 2008 and the President of India has assented the bill on 7th January 2009 and called as the Limited Liability Partnership Act 2008, the LLP Act 2008. This act has been enacted to make provisions for the formation and regulation of limited liability partnership and for matters connected therewith or incidental thereto. The LLP Act 2008 has 81 sections, of which Section 81 is now omitted with effect from 1st April 2022, and four schedules. The first schedule deals with mutual rights and duties of partners and limited liability partnership and its partners where there is an absence of a formal agreement amongst them. The second schedule deals with conversion of LLP from a firm into LLP. The third schedule deals with conversion of a private company into LLP. The fourth schedule deals with conversion of an unlisted public company into LLP. The Ministry of Corporate Affairs and the Registrar of Companies are entrusted with the task of administrating the LLP Act 2008. The central government has the authority to frame the rules with regard to the LLP Act 2008 and can amend them by notifications in the official gazette from time to time. It is also to be noted that the Indian Partnership Act 1932 is not applicable to LLP. Note: the Limited Liability Partnership Act 2008 has been recently amended through the Limited Liability Partnership Amendment Act 2021, date 13th August 2021. The need of new form of limited liability partnership. The lawmakers envisaged the need for bringing out a new legislation for creation of the limited liability partnership to meet up the contemporary growth of Indian economy. A need has been felt for a new corporate form that would provide an alternative to the traditional partnership with an unlimited personal liability on the one hand and the statute-based governance structure of the limited liability company on the other. In order to enable professional expertise and entrepreneurial initiatives and to combine and operate in flexible, innovative, and efficient manner, the LLP Act 2008 was enacted. Thus, LLP as a form of business organization is an alternative corporate business vehicle. It provides the benefit of a limited liability but allows its members the flexibility of organizing their internal structure as a partnership based on the mutual agreements. The LLP form enables entrepreneurs, professionals, and enterprises providing services of any kind or engaged in scientific and technical disciplines to form commercially efficient vehicles suit to their requirement. Owing to flexibility in its structure and operation, the LLP is a suitable vehicle for small enterprises and for investment by venture capital. Limited liability partnership meaning and concept. LLP is a new form of legal business entity with limited liability. It is an alternative corporate business vehicle that not only gives the benefit of limited liability at low compliance cost but allows its partners the flexibility of organizing their internal structure as a traditional partnership. The LLP is a separate legal entity, and while the LLP itself will be liable to the full extent of its asset, the liability of partners will be limited to the extent of their capital contribution. LLP as a separate legal entity and business organization is an alternative corporate business firm that gives the benefit of limited liability of a company and the flexibility of partnership. Since LLP contains element of both a corporate structure as well as a partnership firm structure, LLP is called a hybrid business between a company and a partnership. Definition. First, address. Section 2(1)(a). Address. In relation to a partner of a limited liability partnership means if an individual his usual residential address and if a body corporate the address of its registered office. Body corporate. Section 2, subsection 1 D. It means a company as defined in clause of 20 of section 2 of the Companies Act 2013 and includes a LLP registered under this act, LLP incorporated outside India, and a company incorporated outside India but does not include a corporation sole, a cooperative society registered under any law for the time being in force, and any other body corporate not being a company as defined in clause 20 of section 2 of the Companies Act 2030 or 13 or a limited liability partnership as defined in this act, which the central government may by notification in official gazette specify in this behalf. 3. Business. Section 2 1E. Business includes every trade, profession, service, and occupation except any activity which the central government by notification may exclude. Chartered Accountant. Section 2(1)(f) means a chartered accountant as defined in clause B of subsection 1 of section 2 of the Chartered Accountant Act 1949 and who has obtained a certificate of practice under subsection 1 of section 6 of that act. Designated partner. Section 2(1)(j). Designated partner means any partner designated as such pursuant to section 7. Entities. Section 2(1)(k). Entity means any body corporate and includes for the purpose of section 18, 46, 47, 48, 49, 50, 52 and 53 a firm set up under the Indian Partnership Act 1932. Financial years. Section 2(1)(i). Financial year in relation to a LLP means the period from the first day of April of a year to the 31st day of March of the following year. However, in case of LLP incorporated after 30th day of September of a year, the financial year may end on the 31st day of March of the year next following that year. If a LLP has been incorporated on 15th October 2022, then its financial year may be from 15th October 2022 to 31st March 2024. However, the LLP can always maintain its first accounts from 15th October 2022 to 31st March 2023, that is for a period of less than 12 months. The period for which the first account of LLP are prepared shall not exceed 18 months. The Income Tax Department has prescribed uniform financial year from 1 April to 31st March of next year. In keeping with the income tax law, the financial year for LLP should be from 1st April to 31st March each year. For an LLP, Section 2(1)(m). It means a LLP formed, incorporated, or registered outside India, which establishes a place of business within India. Limited liability partnership. Section 2(1)(n). Limited liability partnership means a partnership formed and registered under this Act. Limited liability partnership agreement. Section 2(1)(o). It means any written agreement between the partners of the LLP or between the LLP and its partner which determines the mutual rights and duties of the partner and their rights and duties in relation to that LLP. The first schedule shall be applicable for all matter not covered by the agreement where with respect to the mutual rights and duties of partners and their rights and duties in relation to LLP. Name. Section 2(1)(p). In relation to a partners of a LLP, a limited liability partnership means if an individual his forename, middle name and surname, and if a body corporates its registered name. Partners. Section 2(1)(q). Partner in relation to a LLP means any person who becomes a partner in the LLP in accordance with the LLP agreement. Regional directors. Section 2(1)(ra) or means a person appointed as such by the central government for the purpose of this act or the Companies Act 2013 as the case may be. Registrar. Section 21S means a person appointed by central government as registrar, an additional registrar, a joint registrar, a deputy registrar, or a assistant registrar for the purpose of this act or the Companies Act 2013 as the case may be. Small limited liability partnership. Section 21T. It means a limited liability partnership the contribution of which does not exceed 25 lakhs or such higher amount not exceeding 5 crore rupees as may be prescribed. The turnover of which, as per the statement of accounts and solvency for the immediate preceding financial year, does not exceed 40 lakhs rupees or such higher amount, not exceeding 50 crore rupees as may be prescribed or which meets such other requirement as may be prescribed and fulfilled such terms and conditions as may be prescribed. Tribunals. Section 21U means the National Company Law Tribunal constituted under Section 408 of Companies Act 2013. Note: applicability of Companies Act 2013. Words and expression used and not defined in this act but defined in the Companies Act 2013 shall have the meaning respectively assigned to them in that act. Section 2, Clause 2. Non-applicability of Indian Partnership Act 1932, save as otherwise provided, the provisions of the Indian Partnership Act 1932 shall not apply to a LLP Act. Section 4. Characteristic of LLP. First, body corporate, perpetual succession, separate legal entity, mutual agency, LLP agreement, artificial legal person, common seal, limited liability, management of business, minimum and maximum number of members, business for profit only, investigation, compromise or arrangements, conversion into LLP, e-filing of government of documents, foreign LLP. LLP is a body corporate. Section 21D of the LLP Act 2008 provides that a LLP is a body corporate formed and incorporated under this Act. Section 3 of the LLP Act provides that LLP is a legal entity separate from that of its partners and shall have perpetual succession. Therefore, any changes in the partners of a LLP should not affect the existence, rights, or liabilities of the LLP. Perpetual succession. The LLP can continue its existence irrespective of changes in partners. Death, insanity, retirement, or insolvency of partner has no impact on the existence of LLP. It is capable of entering into contract and holding property in its own name. Separate legal entities. Section 3 of LLP Act provides that a LLP is a body corporate formed and incorporated under this Act and is a legal entity separate from that of its partners. The LLP is liable to the full extent of the asset, but liability of partner is limited to their agreed contribution in the LLP. In other words, creditors of LLP shall be the creditors of LLP alone. Mutual agency. No partner is liable on account of the independent or unauthorized action of other partners. Thus, individual partners are shielded from joint liability created by another partner's wrongful business decision or misconducts. In other words, all the partners will be the agent of LLP alone. No partner can bind the other partner by his act. LLP agreement. Mutual rights and duties of the partners within a LLP are governed by an agreement between the partners. The LLP Act 2008 provides flexibility to the partners to devise the agreement as per their choice. In the absence of such agreement, the mutual rights and duties shall be governed by Schedule 1 of the LLP Act 2008. Artificial legal person. A LLP is an artificial legal person. It is created by a legal process and is clothed with all rights of an individual. It can do everything which any natural person can do, except, of course, that it cannot be sent to jail, cannot take a oath, cannot marry or get divorced, nor can it practice a learned profession like CA or medicine. The LLP is invisible, intangible, immortal, but not fictitious because it really exists. Common seal. A LLP, being an artificial person, can act through its partners and designated partners. LLP may have a common seal if it decides to have one. Section 14C. Thus, it is not mandatory for a LLP to have a common seal. It shall remain under the custody of some responsible officials, and it shall be affixed in the presence of at least two designated partners of the LLP. Limited liability. Every partner of a LLP is for purpose of the business of LLP the agent of the LLP but not of other partners. The liability of partners will be limited to their agreed contribution in LLP. Such contribution may be of tangible or intangible nature or both. The professionals like engineering consultants, legal advisors, and accounting professionals are afraid of entering into business due to unlimited liability. Hence, the LLP Act provides an avenue for these professionals to enter into limited liability partnership firms which restrict their liability to the agreed amount. This has encouraged professionals to form LLP. Management of business. The partners in the LLP are entitled to manage the business of LLP, but only the designated partners are responsible for legal compliance. Minimum and maximum number of partners. Every LLP shall have at least two partners and shall also have at least two individuals as designated pastor, of whom at least one shall be resident in India. There is no maximum limit on the partners in LLP. Business for profit only. The essential requirement for forming LLP is carrying on a lawful business with a view to earn profit. Thus, LLP cannot be formed by charitable or non-economic purposes. Investigation. The central government shall have power to investigate the affairs of an LLP by appointment of component authority for the purpose. Compromise or arrangement. Any compromise or agreement, including merger and amalgamation of LLP, shall be in accordance with the provisions of LLP Act 2008. Conversion into LLP. A firm, private company, or an unlisted public company would be allowed to be converted into LLP in accordance with the provision of LLP Act 2008. E-filing of documents. Every form or application of document required to be filled or delivered under the Act and rule made thereunder shall be filed in computer readable electronic form on its website www.mca.gov.in and authenticated by a partner or designated partner of LLP by the use of electronic or digital signature. Foreign LLP. Section 21M defines foreign limited liability partnership as a limited liability partnership formed, incorporated, or registered outside India, which establishes a place of business within India. Foreign LLP can become a partner in an Indian LLP. Advantages of LLP. LLP form is a form of business or module which is organized and operate on the basis of an agreement, provide flexibility without imposing detailed legal and procedural requirements, easy to form, all partners enjoy limited liability, easy to dissolve. Partners. Any individual or body corporate may be a partner in a LLP. However, an individual shall not be capable of becoming a partner of LLP according to Section 5 if he has been found to be of unsound mind by a court or competent jurisdiction and the finding is in force, he is an undischarged insolvent, or he has applied to be adjudicated as an insolvent and his application is pending. The following person can become partners in LLP. Individual, resident Indian, including non-resident Indians and overseas citizen of India as well as foreign nationals. Limited liability partnerships. Companies, including foreign companies. Foreign limited liability partnerships. Limited liability partnerships incorporated outside India. Foreign companies. Cooperative societies and cooperation souls cannot become partners in a LLP. In case of introduction of capital acquisition of existing stake in LLP by person resident outside India other than NRI and OCIs, investment on a non-repartition basis, the foreign direct investment compliance shall have to be undertaken by the LLP in which such investment is made. Minimum number of partners. Section 6. Every LLP shall have at least two partners. If at any time the number of partners of a LLP is reduced below 2 and the LLP carries on the business for more than 6 months, while the number is so reduced, the person who is the only partner of LLP during the time that is so carried on the business after those 6 months and has the knowledge of that fact that it is carrying on the business with him alone shall be liable personally for the obligation of LLP incurred during the period. Designated partner. Section 7. First, every LLP shall have at least two designated partners who are individual and at least one of them shall be a resident in India, provided if in LLP all the partners are body corporates or in which one or more partners are individuals and body corporates, at least two individuals who are partners of such LLP or nominees of such a body corporate shall act as designated partner. Example 3. LLP has three partners, one individual, Mr. X, and two body corporates, Mr. XYZ and Mr. ABC Limited. In this case, Mr. X and one nominee of any body corporates shall be designated partner. A LLP by the name SMY LLP has three partners, namely SI Limited, MIS Limited, and YI Limited, Private Limited. As there is no individual as partner in LLP, nominees of any two-side body corporate shall act as designated partners. Resident in India. For the purpose of this section, the term resident in India means a person who has stayed in India for a period of not less than 120 days during the financial year. Example 5. There is an LLP by the name Indian Helicopter LLP having five partners, namely Mr. A, Mr. B, Mr. C, Mrs. D, Mrs. E. In this case, at least two should be named as designated partner, out of which one should be resident. Hence, if Mr. A and Mr. B are designated, then it will not serve the purpose. One of the designated partners should be there out of C, Mrs. C, Mrs. D, and Mrs. E. 2. If the incorporation document specifies who are to be designated partners, such persons shall be designated partner on incorporation or states that each of the partner from the time to time of LLP is to be designated partner. Every partner shall be a designated partner. Any partner may become a designated partner and by, by and in accordance with the LLP agreement, and the partners may cease to be a designated partner in accordance with the LLP agreement. An individual shall not become a designated partner in any LLP unless he has given his prior consent to act as such to the LLP in such form of manner as may be prescribed. Every LLP shall file with the registrar or the particular of every individual who has given his consent to act as designated partner in such form and manner as may be prescribed within 30 days of his appointment. An individual eligible to be a designated partner shall satisfy such conditions and requirements as may be prescribed. Every designated partner of LLP shall obtain a designated partner identification number from the central government, and the provisions of section 153 to 159 of the of the Companies Act 2013 shall apply matrice mentoris for the said purpose. Liabilities of designated partners. Unless expressly provided otherwise in this Act, a designated partner shall be responsible for the doing of all acts, matters, and things as are required to be done by the limited liability partnership in respect of compliance of the provisions of this Act, including filling of any document, return statement, and the like report pursuant to the provisions of this Act and as may be specified in the Limited Liability Partnership Act, and liable to all penalties imposed on the LLP for any contravention of those provisions. Change in designated partners. Section 9. A limited liability partnership may appoint a designated partner within 30 days of a vacancy arising for any reason, and provision of subsection 4 and subsection 5 of section 7 shall apply in respect of such new designated partner, provided that if no designated partner is appointed, or if at any time there is only one designated partner, each partner shall be deemed to be a designated partner. Punishment for contravention of section 7 and section 9 according to section 10. If LLP contravenes the provisions of subsection 1 of section 7, meaning that the number of designated partners are less than 2, or none of the designated partner is a resident in India, the LLP and its every partner shall be liable to a penalty of 10,000, and in case of continuing contravention with further penalty of 100 per day, subject to the maximum 1 lakh for LLP and 50,000 for every partner of such LLP. If the LLP contravenes the provision of subsection 4 of section 7, failure to file the consent of the appointment of designated partners within 30 days of his appointment, the LLP and its every designated partner shall be liable to a penalty of 5,000, and in case of continuing contravention with the penalty of rupees 100 per day, subject to maximum 50,000 for LLP and 25,000 for every designated partner. If the LLP contravenes the provisions of subsection 5 of section 7 or section 9, the LLP and its every partner shall be liable to the penalty of 10,000, and in case of continuing contravention with a further penalty of 100 per day, subject to maximum 1 lakh for LLP and 50,000 for every partner in such LLP. Incorporation of an LLP. Incorporation document, section 11. The most important document needed for registration is the incorporation document. First, for a LLP to be incorporated, two or more persons associated for carrying on a lawful business with a view to earn profit shall subscribe their name to an incorporation document. The incorporation document shall be filed in such manner and with such fees as may be prescribed with the registrar of the state. In documents are now processed electronically by registrar Central Registration Center since 2nd October 2018, and statement to be filed first. There shall be filled along with the incorporation document a statement in prescribed form made by either an advocate or a company secretary or a chartered accountant or a cost accountant who is engaged in the formation of LLP, and by any one who subscribe his name to the incorporation document, that all the requirements of this act and the rules made thereunder have been compiled with. In respect of incorporation and matter precedent and incidental thereto, the incorporation document shall be in a form as may be prescribed, state the name of the LLP, state the proposed business of the LLP, state the address of registered office of the LLP, state the name and address of each of the person who are to be partner of the LLP, state the name and the address of the person who are to be designated partner of the LLP on incorporation, and contain such other information concerning the proposed LLP as may be prescribed. If a person makes a statement as discussed above which he knows to be false or does not believe to be true, shall be punishable penalty for false declaration with imprisonment for a term which may extend to 2 years, and with fine which shall not be less than 10,000 but which may extend to 5 lakhs. Incorporation by registration. Section 12. When the requirement imposed by clause B and C of subsection 1 of section 11 have been compiled with, the registrar shall retain the incorporation document, and unless the requirement imposed by clause A of the subsection has not been compiled with, he shall within a period of 14 days register the incorporation document and give a certificate that the LLP is incorporated by the name specified therein. The registrar may accept the statement delivered under clause C, subsection 1 of section 11 as sufficient evidence that the requirement imposed by clause A of that subsection has been complied with. The certificate issued under clause B of subsection 1 shall be signed by the registrar and authenticated by his official seal. The certificate shall be conclusive evidence that the LLP is incorporated by the name specified therein. Registered Office of LLP and change therein. Section 13. Every LLP shall have a registered office to which all communications and notice may be addressed and where they shall be received. The document may be served on a LLP or a partner or designated partner thereof by sending it by post under a certificate of posting or by registered post or by any other manner as may be prescribed at the registered office and any other address specifically declared by the LLP for the purpose in such form and manner as may be prescribed. A LLP may change the place of its registered office and file the notice of such change with the registrar in such form and such manner and subject to such conditions as may be prescribed and any such changes shall take effect only upon such filing. If the LLP contravenes any provisions of this section, the LLP and its every partner shall be punishable with a penalty of 500 per day, subject to the maximum 50,000. Effect of registration, section 14. On registration, LLP shall by its name be capable of suing and being sued, acquiring, owning, holding, and developing or disposing of property, whether movable or immovable, tangible or intangible, have a common seal if it decides to have one, and doing and suffering others act and things as body corporate may lawfully do and suffer. Name. Section 15. Every limited liability partnership shall have either the word limited liability partnership or the acronym LLP as the last word of its name. No LLP shall be registered by a name which, in the opinion of the central government, is A. undesirable, or B. identical or too nearly resemble to that of any other LLP or a company or a registered trademark of any other person under the Trademark Act 1999. Reservation of name. A person may apply in such form and manner and accompany by such fees as may be prescribed to the registrar for the preservation of name set out in the application as the name of a proposed LLP or the name to which a LLP proposes to change its name. Upon receipt of an application under subsection 1 and on a payment of prescribed fees, the registrar may, if he is satisfied, subject to the rules prescribed by the central government in the matter that the name to be reserved is not one which may be rejected on any grounds referred to in subsection 2 of section 50, reserve the name for a period of 3 months from the date of intimation by the registrar. This is all in section 16. Rectification of name of LLP. Notwithstanding with anything contained in section 15 and 16, if through any adverent or otherwise the LLP on its first registration or on its registration by new name is registered by a name which is identical with two nearly resembles to that of any other LLP or a company or a registered trademark of a proprietor under the Trademark Act 1999 as likely to be mistaken, then on an application of such LLP or proprietor referred to in clause A and B respectively or a company, the central government may direct such LLP to change its name or new name within a period of 3 months from the date of issue of such direction, provided that an application of the period of the registered trademark shall be maintainable within a period of 3 years from the date of incorporation or registration or change of name of the LLP under this Act. Where a LLP changes its name or obtain new name, it shall within a period of 15 days from the date of such changes give notice of the change to the registrar along with the order of the central government, who shall carry out necessary changes in the certificate of incorporation, and within 30 days of such change in the certificate of incorporation such LLP shall changes its name in the LLP agreement. If the LLP is in default in complying with any direction given under subsection 1, the central government shall allot a new name to the LLP and the registrar shall enter the new name in the register of LLP in place of the old name and issue a fresh certificate of incorporation with new name, provided that nothing contained in this subsection shall prevent LLP from subsequently changing its name. Steps to incorporate LLP. First, reservation of name of LLP. Applicant has to fill E-form, run LLP for ascertaining availability and reservation of the name of an LLP. Step 2. Fill E-form, fill IP for incorporation a new LLP. In the detail of proposed LLP, details of designated partners and their consent. Execution of LLP agreement is mandatory as per Section 23 of the Act. It will be filled in E-form 3 within 30 days of incorporation of LLP. Partners and their relations. Eligibility to be partner, Section 22. On the incorporation of a LLP, the person who subscribed their name to the incorporation document shall be its partner, and any other person who become a partner of the LLP by and in accordance with the LLP agreement. Relationships of partners, Section 23. Save as otherwise provided by this Act, the mutual rights and duties of the partners of LLP and the mutual rights and the duties of LLP and its partners shall be governed by the LLP agreement between the partner or between the LLP and its partners. The LLP agreement and any changes, if any, made therein shall be filed with the registrar in such form, manner, and accompanied by such fees as may be prescribed. An agreement in written made before the incorporation of LLP between the person who subscribed their name to the incorporation document may impose obligation on the LLP provided such agreement is ratified by the partners after the incorporation of the LLP. In the absence of agreement as to any matter, the mutual rights and duties of the partners and the mutual rights and duties of the LLP and the partners shall be determined by the provisions relating to that matter as are set out in the first schedule. Cessation of partnership interest. A person may cease to be partner of LLP in accordance with an agreement with the other partner or in the absence of agreement with the other partner as to cessation of being a partner by giving a notice in writing of not less than 30 days to the other partners of his intention to resign as partner. A person shall cease to be a partner of LLP on his death or dissolution of LLP, or if he declares is declared to be of unsound mind by a competent court, or if he has applied to be adjudicated as an insolvent or declared as insolvent. Third, where a person has ceased to be a partner of LLP, the former partner is to be regarded in relation to any person dealing with the LLP as still being a partner of LLP unless the person has noticed that the former partner has ceased to be a partner of the LLP, or notice that the former partner has ceased to be a partner of LLP has been delivered to the registrar. The cessation of a partner from the LLP does not by itself discharge the partner from any obligation to the LLP or to the other partners or to any other person which he incurred while being a partner. Where a partner of LLP ceases to be a partner unless otherwise provided in the LLP agreement, the former partner or a person entitled to his share in consequences of death or insolvency of the former partner shall be entitled to receive from the LLP an amount equal to the capital contribution of the former partner actually made to the LLP, and his right to share in the accumulated profit of the LLP after the deduction of accumulated losses of LLP determined as at the date the former partner ceased to be a partner. 6. A former partner or a person entitled to his share in consequences of the death of or insolvency of the former partner shall not have any right to interfere in the management of LLP. Registration of changes in partners. Section 25. Every partner shall inform the LLP of any changes in his name or address within a period of 15 days of such changes. Second, a LLP shall, where a person becomes or ceases to be a partner, file a notice with the registrar within 30 days from the date he becomes or ceases to be a partner, and where there is any change in the name or address of a partner, file a notice with the registrar within 30 days of such changes. A notice filed with the registrar under subsection 2 shall be in such form and accompanied by such fees as may be prescribed, shall be signed by the designated partner of the LLP and authenticated in a manner as may be prescribed, and if it relates to an incoming partner, shall contain a statement by such partners that he consents to become a partner, signed by him and authenticated in the manner as may be prescribed. If the LLP contravenes the provision of subsection 2, the LLP and every designated partner of the LLP shall be liable to penalty of rupees 10,000. If any partner contravenes the provision of subsection 1, such partner shall be liable to a penalty of 10,000. Any person who ceases to be a partner of LLP may himself file with the registrar the notice referred to in subsection 3 if he has reasonable cause to believe that the LLP may not file the notice with the registrar, and in case of any such notice filed by a partner, the registrar shall obtain a confirmation to this effect from the LLP unless the LLP has also filed such notice. However, where no confirmation is given by the LLP within 15 days, the registrar shall register the notice made by a person ceasing to be a partner under this section. Extension and limitation of liability of LLP and partners. Partner as an agent. Section 26. Every partner of LLP is for the purpose of the business of the LLP, the agent of LLP, but not of other partners. Extent of liability of LLP. Section 27. LLP is not bound by anything done by a partner in dealing with a person if the partner in fact has no authority to act for the LLP in doing a particular act, and the person knows that he has no authority or does not know or believe him to be a partner of the LLP. The LLP is liable if a partner of the LLP is liable to any person as a result of wrongful act or omission of his part in the course of business of the LLP or with its authority. An obligation of the LLP, whether arising in contract or otherwise, shall be solely the obligation of LLP. The liabilities of the LLP shall be met out of the property of the LLP. Extent of liability of partner. A partner is not personally liable directly or indirectly for an obligation referred to in subsection 3 of section 27 solely by reason of being a partner of the LLP. The provision of subsection 3 of section 27 and subsection 1 of this section shall not affect the personal liability of partner for his own wrongful act or omission, but a partner shall not be personally liable for the wrongful act or omission of any other partner of the LLP. Holding out. Section 29. Any person who by word, spoken or written or by conduct represents himself or knowingly permits himself to be represented to be a partner in a LLP is liable to any person who has on the good faith of any such representation given credit to the LLP, whether the person representing himself or represented to be a partner does not know that the representation has reached the person so given credit. However, where any credit is received by the LLP as a result of such representation, the LLP shall, without prejudice to the liability of the person so representing himself or representing to be a partner, be liable to the extent of credit received by it and or any financial benefit delivered thereon. Where after a partner's death the business is continued in the same LLP name, the continued use of that name or of the deceased partner's name as a part thereof shall not by itself make his legal representative or his estate liable for any act of the LLP done after the death. Unlimited liability in case of fraud. Section 30. In case of fraud, in the event of an act carried out by a LLP or any other of its partner with intention to defraud creditors of the LLP or any other person or for any fraudulent purpose, the liability of LLP and partner who acted with intention to defraud creditor or for any fraudulent purposes shall be unlimited for all or any of the debt or other liabilities of LLP. However, in case such act is carried out by a partner, the LLP is liable to the same extent as the partner unless it is established by the LLP that such act was without the knowledge or the authority of LLP. Second, where any business is carried on with such intention or for such purpose as mentioned in subsection 1, every person who was knowingly a part to the carrying on the business in the manner of foresight shall be punishable with imprisonment for a term which may extend to 5 years, and with fine which shall not be less than 50,000 but which may extend to 5 lakhs, where LLP or any partner or designated partner or employee of such LLP has conducted the affairs of the LLP in a fraudulent manner, then without prejudice to any criminal proceedings which may arise under any law for the time being in force, the LLP and any such partner or designated partner or employee shall be liable to pay compensation to any person who has suffered any loss or damage by reason of such conduct. However, such LLP shall not be liable if any such partner or designated partner or employee has acted fraudulently without knowledge of the LLP. Whistleblower. Section 31. The court or tribunal may reduce or waive off any penalty leviable against any partner or employee of LLP if it is satisfied that such partner or employee of an LLP has provided useful information during investigation of such LLP, or when any information given by any partner or employee leads to LLP or any partner or employee of such LLP being convicted under this act or any other act. No partner or employee of any LLP may be discharged, demoted, suspended, threatened, harassed, or in any other manner discriminated against the terms and conditions of his LLP or employment merely because of his providing information or causing information to be provided pursuant to subsection 1. Contribution. Forms of contribution. Section 32. A contribution of a partner may consist of a tangible, movable or immovable or intangible property or other benefits to the limited liability partnership, including money, promissory note, other agreements to contribute cash or property, and to contract for services performed or to be performed. The monetary value of the contribution of each partner shall be accounted for and disclosed in the accounts of the limited liability partnership in the manner as may be prescribed. Obligations to contribute. Section 33. The obligation of a partner to contribute money or other property or other benefit or to perform service for a limited liability partnership shall be as per the limited liability partnership agreement. A creditor of a limited liability partnership which extends credit or otherwise acts in reliance on an obligation described in that agreement without notice of any compromise between partners may enforce the original obligation against such partners. Financial disclosures. First, maintain proper books of account in prescribed manner. File statement of account and solvency within 6 months from end of each financial year. Statement of account and solvency shall be filed with the registrar every year in prescribed form and manner with prescribed fee. Audit of accounts of central government may exempt. Maintenance of books of account, other records, audit, etc. Section 34. First, proper books of account. The LLP shall maintain such proper books of account as may be prescribed, relating to its affair for each year of its existence, on cash basis or accrual basis and according to double entry system of accounting, and shall maintain the same at its registered office for such period as may be prescribed. Statement of account and solvency. Every LLP shall within a period of 6 months from the end of each financial year prepare a statement of account and solvency for the said financial year as at the last day of the said financial year in such form as may be prescribed, and such statement shall be signed by the designated partner of the LLP. Every LLP shall file within the prescribed time the statement of account and solvency prepared pursuant to subsection 2 with the registrar every year in such form and manner and accompanied by such fees as may be prescribed. The account of LLP shall be audited in accordance with such rules as may be prescribed. However, the central government may, by notification in official gazette, exempt any class or classes of LLP from the requirement of this subsection. Penalty for non-compliance of the provision of subsection 3 LLP rupees 100 per day, subject to maximum 1 lakh rupees, Every designated partner 100 per day subject to maximum 50,000 rupees and penalty for non-compliance of provisions of subsection 1, 2 and 4 LLP not less than 25,000 which may extend to 5 lakhs and every designated partner not less than 10,000 which may extend to 1 lakh. Accounting and Auditing Standards Section 34A. Central government may in constitution with the National Financial Report Authority constituted under Section 132 of Companies Act 2013 prescribe the standard of accounting and prescribe the standard of auditing as recommended by ICAI. Annual returns. Section 35. Every LLP shall file an annual return duly authenticated with the registrar within 60 days of closure of its financial year, in such form and manner, and accompanied by such fees as may be prescribed. Suppose the financial year of a LLP closes on 31st March 2022, then the LLP has to file an annual return with the registrar latest by 30th May 2022. Note: the LLP, contradistinct from Partnership Act 1932, has prescribed the filing of annual returns in accordance with the Companies Act 2013. This is a new feature of the LLP. Penalty for non-filing of annual returns. LLP rupees 100 per day subject to maximum 1 lakh rupees. Every designated partner rupees 100 per day subject to maximum rupees 50,000. Inspection of document kept by registrar. Section 36. The incorporation document, name of partner and changes, if any, made with therein, statement of account and solvency, and annual return filed by each LLP with the registrar shall be available for inspection by any person in such a manner and on payment of such fees as may be prescribed. Penalty for false statement. Section 37. If in any result, return, statement or other document required by or for the purpose of any of the provision of this act, any person makes a statement which is false in any material particular knowing it to be false, or which may omit any material fact knowing it to be material, he shall save as otherwise expressly provided in this act, be punishable with imprisonment for a term which may extend to 2 years, and shall not also be liable to fine which may extend to 5 lakh rupees, but which shall not be less than 1 lakh rupees. Power of registrar to obtain information. In order to obtain such information as the registrar may consider necessary for the purpose of carrying out the provisions of this act, the registrar may require any person, including any present or former partner or designated partner or employee of a limited liability partnership, to answer any question or make any declaration or supply any detail or particular in written to him within a reasonable period of time. In case any person referred to in subsection 1 does not answer such question or make such declaration or supply such details or particular asked for by the registrar within a reasonable time or time given by the registrar, or when the registrar is not satisfied with the reply or declaration or detail or particular provided by such person, the registrar shall have power to summon that person to appear before him, or an inspector or any other public officer whom the registrar may designate to answer any such question or make such declaration or supply such detail as the case may be. Any person who without lawful excuse fails to comply with any summons or requisition of the registrar under this section shall be punishable with fine which shall not be less than 2,000 rupees, but which may extend to 25,000 rupees. Compounding of offences. Notwithstanding anything contained in the section 39 in the Code of Criminal Procedure 1973, the regional director or any other officer not below the rank of regional director authorized by the central government may compound any offence under this act, which is punishable with fine only, by collecting from a person reasonably suspected of having committed the offence a sum which may extend to the amount of maximum fine provided for the offence, but shall not be lower than the minimum amount provided for the offence. Nothing contained in subsection 1 shall apply to an offence committed by a limited liability partnership or its partner or its designated partner within a period of 3 years from the date on which similar offense committed by it or him was compounded under this section. Explanation: for the removal of doubt, it is hereby clarified that any second or subsequent offense committed after the expiry of the period of 3 years from the date on which the offense was previously compounded shall be deemed to be the first offense. Every application for the compounding of an offence shall be made to the registrar, who shall forward the same, together with his comment thereon, to the regional director or any other officer not below the rank of regional director authorized by the central government as the case may be. Where any officer is compounded under this section, whether before or after the institution of any prosecution, intimation thereof shall be given to the registrar within a period of 7 days from the date on which the offence is so compounded. Where any offences is compounded before the institution of any prosecution, no prosecution shall be instituted in relation to such offences. Where the compounding of any offence is made after the institution of any prosecution, such compounding shall be brought by the registrar in writing to the notice of the court in which prosecution is pending, and on such notice of the compounding of the offence being given, the offender in relation to which the offences is so compounded shall be discharged. The regional director or any other officer not below the rank of regional director authorized by the central government while dealing with the proposal for compounding of an offence may by an order direct any partner, designated partner or other employee of the LLP to file or register or on payment of fees or additional fees as required to be paid under this act such return, account or other document within such time as may be specifying in the order. Notwithstanding anything contained in this section, if any partner or designated partner or other employee of this LLP who fails to comply with any order made by the regional director or any other officer not below the rank of regional director authorized by central government under subsection 7, the maximum amount of fine for the offence which was under consideration, regional director of such authorized officer for compounding under this section shall be twice the amount provided in the compounding section in which punishment for such offences is provided. Assignment and transfer of partnership rights. Partners transferable interest, section 42. The right of partner to a share of the profit and loss of the limited liability partnership and to receive distributions in accordance with the limited liability partnership agreement are transferable either wholly or in part. The transfer of any right by any partner pursuant to subsection 1 does not by itself cause the dissociation of the partner or a dissolution and winding up of the limited liability partnership. The transfer of right pursuant to this section does not by itself entitle the transferee or assignee to participate in the management or conduct of the activity of the limited liability partnership or access information concerning the transaction of the limited liability partnership. Conversion into LLP. Conversion from firm into LLP. Section 55. A firm may convert into an LLP in accordance with the provisions of this chapter and the second schedule. Conversion from private company into LLP. Section 56. A private company may convert into an LLP in accordance with the provisions of this chapter and the third schedule. Conversion from unlisted public company into LLP. Section 57. An unlisted public company may convert into an LLP in accordance with the provision of this chapter and the fourth schedule. Registration and effect of conversion. The registrar, on satisfying that a firm, private company, or an unlisted public company, as the case may be, has complied with the respective schedule provisions of this act and the rules made thereunder, register the document submitted under such schedule and issue a certificate of registration in such form as the registrar may determine, stating that the LLP is on and from the date specified in the certificate registered under the Act. The LLP shall within 15 days of date of registration inform the concerned registrar of the firm of registrar of company as the case may be with which it was registered under the provision of Indian Partnership Act or the Companies Act 1956 now 2013 as the case may be about the conversion and of the particulars of the LLP in such a form and manner as may be prescribed. Upon such conversion, the partners of the firm, the shareholders of the private company or unlisted public company, as the case may be, the LLP to which such firm or such company has converted, and the partners of the LLP shall be bound by the respective schedule, as the case may be, applicable to them. Upon such conversion, on and from the date of certificate of registration, the effect of the conversion shall be such as specified in the respective schedule as the case may be. Effect of registration. Notwithstanding anything containing in any other law for the time being in force on and from the date of registration specified in the certificate of registration issued under the respective schedule as the case may be, there shall be a LLP by the name specified in the certificate of registration registered under this act. All tangible and intangible property vested in the firm or the company as the case may be, all asset, interest, rights, privileges, liabilities, obligations relating to the firm of, or the company as the case may be, and the whole of the undertakings of the firm or the company as the case may be, shall be transferred to to and shall vest in the limited liability partnership without further assurance, act or deed, and the firm or the company, as the case may be, shall be deemed to be dissolved and removed from the record of the registrar of firms or registrar of companies, as the case may be. Foreign LLP. Foreign LLP Section 59. The central government may make rules for provisions in relation to the establishment of place of business by foreign LLP within India and carry on their businesses therein by applying or incorporating with such modification as appear appropriate the provisions of the Companies Act 2013 or such regulatory mechanism with such composite as may be prescribed. Compromise, arrangement, or reconstruction of limited liability partnership. Compromise or arrangement of limited liability partnership, section 60, where a compromise or arrangement is proposed between a limited liability partnership and its creditor or between a limited liability partnership and its partners. The tribunal may, on the application of the limited liability partnership or of the any creditor or partner of the limited liability partnership, or in the case of a limited liability partnership which is being wound up of the liquidator, order a meeting of the creditor or of the partner as the case may be to be called, held and conducted in such manner as may be prescribed or as the tribunal directs. If a majority represent three-fourths in value of the creditor or partners as the case may be at the meeting agree to any compromise or arrangement, the compromise or arrangement shall, if sanctioned by the tribunal, by order be binding on all the creditors or all the partners as the case may be, and also on the limited liability partnership, or in the case of a limited liability partnership which is being wound up on the liquidator or contributes of the limited liability partnership, provided that no order sanction any compromise or arrangement shall be made by the tribunal unless the tribunal is satisfied that the limited liability partnership or any other person by whom an application has been made under subsection 1 has disclosed to the tribunal by affidavit or otherwise all material facts relating to the limited liability partnership, including the last financial position of the limited liability partnership, the pendency of any investigation proceeding in relation to the limited liability partnership. An order made by the tribunal under subsection 2 shall be filed by the limited liability partnership with the registrar within 30 days after making such an order and shall have effect only after it is so filed. If default is made in complying with the provisions of subsection 3, the LLP and its every designated partner shall be liable to a penalty of rupees 10,000 and in case of continuing default, while further penalty of rupees 100 for each day after the first during which such default continues, subject to maximum 1 lakh for LLP and 50,000 for every designated partner. The tribunal may at any time after an application has been made to it under this section stay the commencement or continuation of any suit or proceedings against the limited liability partnership on such terms as the tribunal thinks fit until the application is finally dissolved or disposed. Power of tribunal to enforce compromise or arrangement, section 61. Where the tribunal makes an order under section 60 sanctions a compromise or an agreement arrangement in respect of a limited liability partnership, it shall have power to supervise the carrying out of the compromise or arrangement and may at the time of making such order or at any time thereafter give such direction in regard to any matter or make such modifications in the comparison or arrangement as it may consider necessary for proper work of the compromise or arrangement. If the tribunal aforesaid is satisfied that a compromise or an arrangement sanctioned under Section 60 cannot be worked satisfactorily with or without modification, it may either on its own monitor or on the application of any person interested in the affairs of the limited liability partnership make an order for winding up the limited liability partnership, and such an order shall be deemed to be an order made under Section 64 of this Act. Provisions for felicitating reconstruction or amalgamation of limited liability partnerships, Section 62. Where an application is made to the tribunal under Section 60 for sanctioning of a compromise or arrangement proposed between a limited liability partnership and any such person as are mentioned in that section, and it is shown to the tribunal that the compromise or arrangement has been proposed for the purpose of or in connection with a scheme for the reconstruction of any limited liability partnership or limited liability partnerships or the amalgamation of any two or more limited liability partnerships, and under the scheme the whole or any part of the undertaking property or liability of any limited liability partnership concerned in the scheme is to be transferred to another limited liability partnership. The tribunal may either by the order sanctioning the compromise or arrangement or by a subsequent order make provisions for all or any of the following matters, namely the transfer to the transferee limited liability partnership of the whole or any part of the undertaking property or limited liability of any transferor limited liability partnership, the continuation by or against the transferee limited liability partnership of any legal proceedings pending by or against any transferor limited liability partnership, the dissolution without winding up of any transferor limited liability partnership, the provision to be made for any person who within such time and in such manner as the tribunal direct dissents from the compromise or arrangements, and such incidental consequential and supplemental matter as are necessary to the secure that the reconstruction or amalgamation shall be fully and effectively carried out, provided that no compromise or arrangement proposed for the purposes of or in connection with a scheme for the amalgamation of a limited liability partnership which is being wound up with any other limited liability partnership or limited liability partnerships shall be sanctioned by the tribunal unless the tribunal has received a report from the registrar that the affair of the limited liability partnership have not been conducted in a manner prejudicial to the interest of its partner or to public interest. provided further that no order for the dissolution of any transfer or limited liability partnership under clause 3 shall be made by the tribunal unless the official liquidator has on scrutiny of the book and paper of the limited liability partnership made a report to the tribunal that the affairs of the limited liability partnership have not been conducted in a manner prejudicial to the interest of its partners or to public interest, where an order under this section provides for the transfer of any property or liability, then by virtue of the order that the property shall be transferred to and vested in, and those liabilities shall be transferred to and become the liabilities of the transferee limited liability partnership, and in the case of any property, if the order so direct freed from any charges which is by virtue of the compromise or arrangement to cease to have effect within 30 days after the making of an order under this section, every limited liability partnership in relation to which the order is made shall cause a certified copy thereof to be filed with the registrar for registration. If default is made in complying with the provision of subsection 3, the LLP and its every designated partner shall be liable for a penalty of rupees 10,000 in any case continuing contravention, with the further penalty of rupees 100 for each day after the first during which such default continues, subject to the maximum rupees 1 lakh LLP and 50,000 for every designated partner. Explanation: in this section, property including property, right and powers of every description and liability including duties of every description, a LLP shall not be amalgamated with a company. Winding up and dissolution. Winding up and dissolution. Section 63. The winding up of an LLP may be either voluntary or by the tribunal, and LLP so wound up may be dissolved. Circumstances in which LLP may be wound up by the tribunal. Section 64. A LLP may be wound up by the tribunal if the LLP decides that LLP be wound up by the tribunal, if the if for a period of more than 6 months the number of partners of LLP is reduced below 2, if the LLP has acted against the interest of the sovereignty and integrity of the India, the security of state or public order, if the LLP has made a default in filing with the registrar the statement of account and insolvency or annual return for any 5 consecutive financial years, or if the tribunal is of the opinion that it is just and equitable that the LLP be wound up. Rules for winding up and dissolution. Section 65. The central government may make rules for the provisions in relation to winding up and dissolution of LLP. Miscellaneous business transaction of partner with LLP. Section 66. A partner may lend money to and transact other business with the LLP and has the same right and obligation with respect to the loan or other transactions as a person who is not a partner. Application of provisions of Companies Act Section 67. The central government may, by notification in the official gazette, direct that any of the provision of this Companies Act 1956 specified in the notification shall apply to any LLP or shall apply to any LLP with such exception, modification, and adaptation as may be specified in the notification. A copy of every notification proposed to be issued under subsection 7 shall be laid in draft before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions, and if before the expiry of session, immediately following the session or the successive sessions aforesaid, both houses agree in disapproving the issue of the notification, or both houses agree in making any modification in the notification shall not be issued, or as the case may be, shall be issued only in such modified form as may be agreed upon by both the houses. Payment of additional fees. Section 69. Any document or return required to be registered or filed under this Act with registrar, if is not registered or filed in time provided therein, may be registered or filed after that time on payment of such additional fees as may be prescribed in addition to any fees as is payable for the filing of such document or return, provided that such document or return shall be filed after the due date of filing without prejudice to any other action or liability under this act, provided further that different fees or additional fees may be prescribed for different class of limited liability partnership or for different documents for returns required to be filled under this section act or rule made thereunder. Enhanced punishment section 70, in case a limited liability partnership or any partner or designated partner of such limited liability partnership commit any offense, the limited liability partnership or any partner or designated partner shall be for the second or subsequent offense be punished with the imprisonment as provided, but in case of offenses for which fine is prescribed either along with or exclusive of imprisonment with fine, which shall be twice the amount of fine for such offenses. With other forms of organization. Distinction between LLP and partnership firm. The point of distinction between a LLP and partnership firm are tabulated as follows. Basis: Regulating Act LLP, the Limited Liability Partnership Act 2008. Partnership firm, the Indian Partnership Act 1932. Body corporate, it is a body corporate. It is not a body corporate. Separate legal entity, it is a separate legal entity. It is not a separate legal entity. Creation, it is created by legal process called registration under the LLP Act 2008. It is created by an agreement between the partners. Registration, registration is mandatory. LLP can sue and be sued in its own name. Registration is voluntary. Only the registered partnership can sue the third party. Perpetual succession, death, insanity, retirement, or insolvency of partner does not affect the existence of LLP. Members may join or leave, but its existence continue forever. The death, insanity, retirement, or insolvency of the partners may affect its existence. It has no perpetual succession. Name. Name of the LLP to contain the word limited liability partnership as suffix. No guidelines. The partners can have any name as per their choice. Liability. Liability of each partner limited to the extent of agreed contribution except in case of willful fraud. Liability of each partner is unlimited. It can be extended up to the personal assets of the partners. Mutual agency. Each partner can bind the LLP by his own act but not the other partners. Each partner can bind the firm as well as other partners by his own acts. Designated partners. At least two designated partners and at least one of them shall be resident in India. There is no provision for such partner under the Partnership Act 1932 Common Seal. It may have a common seal as its official signature. There is no such concept in partnership. Legal compliance. Only designated partners are responsible for any compliance and penalties under this Act. All partners are responsible for the compliance and penalties under the Act. Annual filing of document. LLP is required to file statement of account and solvency annual returns with the registration of LLP every year. Partnership firm is not required to file any document with the registrar of firms. Foreign partnership. Foreign nationals can become a partner in an LLP. Foreign nationals cannot become a partner in a partnership firm. Minor as partner. Minor cannot be admitted to the benefit of LLP. Minor can be admitted to the benefit of the partnership with the prior consent of the existing partners. Distinction between LLP and limited liability company. Regulating Act. The LLP Act 2008, the Companies Act 2013. Members, the person who contributes to the LLP are known as partners of the LLP. The person who invests in money in the shares of company are known as members of the company. Internal governance structure. The internal governance structure is governed by contract agreement between the partners. The internal governance structure of the company is regulated by statute. Name. Name of the LLP contain the word LLP as the suffix. Name of the public company to contain the word limited, and company to contain the word private limited as suffix. Number of members, minimum 2 number of members, maximum no such limit on the member in the act. Private company, minimum 2 members, maximum 200. Public companies, minimum 7, maximum no such limit. Liability of members, liability of partners is limited to the extent of agreed contribution. Liability of member is limited to the amount unpaid on the share held by them. Management, the business of the company is managed by the partners, including the designated partner authorized in the agreement. The affairs of the company are managed by board of directors elected by shareholders. Minimum number of directors, minimum 2 designated partners, private company 2 directors, public company 3 directors. Over. Summary. Applicability. From 31st March 2009 extends whole of India. Non-applicability. The Indian Partnership Act 1932 to LLPs. Who can be partner in LLP? Any individual or body corporate may be partner in a LLP, but not person of unsound mind, undischarged, insolvent, or who has applied to be adjudicated as an insolvent. Minimum partners, two partners. If LLP carries on business for more than 6 months with only one partner, he shall be liable personally for the obligation of LLP incurred during the period. Designated partner. At least two designated partners who are individuals and are at least one of them shall be resident in India. Resident in India, a person who has stayed in India for a period of not less than 120 days during the immediately preceding 1 year. Registration of conversion to LLP. Registrar on satisfying will register the document and issue a certificate of registration. Information of conversion to registrar of firms or company by LLP within 15 days for registration. Upon such conversion, provisions of LLP will be applicable. Effect of registration of conversion. There shall be a LLP name by name specified in certificate of registration. All tangible and intangible property of firm or the company shall vest in LLP. Firm or company shall be deemed to be dissolved. Name of LLP. Use of word LLP Limited Liability Partnership as the last word of its name. No LLP registration by a name which in opinion of the central government is undesirable or identical or too nearly resembles to any other partnership, firm or LLP or company or a registered trademarks. Change of name of LLP. If name of registered LLP is identical or too nearly resembles to any other partnership, firm or LLP or company or a registered trademark, CG may direct such LLP to change its name within 3 months. On application, extent and limitations of LLP of liability of LLP and partner. Partner as agent. Agent of the LLP but not of other partner. Liability of LLP. LLP not bound by anything done by a partner if partner has no authority. Obligation of the LLP shall be solely the obligation of the LLP. Liability of LLP shall be met out of the property of LLP. Limited liability of partnership. uh, Partners. Partner is not personally liable for obligations of LLP. Partner in personally liable for his own wrongful act or omission. Unlimited liability in case of fraud. If act carried out by a LLP or partner to defraud creditor, liability of LLP and partner shall be unlimited. Penalty. Imprisonment up to 5 years and fine of 50,000 to 5 lakhs. Default person also liable to pay compensation.